You're not just being informed that even the PO, which we have gained sight of, has not properly been served on us, but that's not an issue here. We will be ready to deal with it.
Our instructions are, we have been served this application now. Filing processes takes time. We will raise issues of law within this application because the PO is about law, either during submissions or outside. Because we don't have it now, we are seeking that we do not deal with the PO as an item per se. Number two, the state has asked for which paragraph that we intend to cross-examine. We shall be cross-examining the deponent from paragraph 5 to paragraph 28. The paragraph that was examined.
So this video, does it work? We do have video.
Yes.
So let's proceed on the premise of your application.
That's fine. Yes.
Once they will raise it, we deal with it as they raise it.
That's right. You know, only that to add that the proper name of a PO is a notice of preliminary regulation, so that we need notice. If they intend to bring a notice in within, let them not throw it within the application because we shall not have notice, or rather sufficient notice to deal with it. But as be that as it may, let me proceed with our application. As is already indicated, our application is dated 16th of June 2025, the year of the Lord. The substantive prayer sought is prayer B on the face of the application. That prayer is that the respondent before court be remanded at the Langata police station or any other police station within the Republic of Kenya and the reason being, and this is the justification, that it will enable the applicant herein through the Independent Policing Oversight Authority to continue and conclude investigations in respect of the facts, the basis of the arrest of the respondent. Your application is based on both law and facts. And to be more specific, Articles 24, 29, 49, of the Constitution and Section 36, capital A, of the Criminal Procedure Code. We will also make references to the decision of the High Court of Kenya at Uhuru, Honorable Justice Joy Ngugi, a judge I hold so highly, in the decision of Sudi Oscar Kichumba versus Republic, and this is Criminal Revision number 208 of 2020. You know, fundamentally, that decision of the learned Justice Ngugi, as he then was, because he now sits at the Court of Appeal, cites and makes reference to the decision of the High Court of Kenya at Milimani, delivered 4 years before it by the learned Justice Luka Kimaru, as he then was as well, because he equally sits at the Court of Appeal, in Michael Rotich versus Republic. And we preempt that the defense are likely to run away with Michael Rotich, so we are going to hit hard on it before they get a chance. You know, in summary, what we are requesting this court to do is to issue an order for what the Constitution calls detention continuing. So that the respondent remains in custody, that's the common name that we call it custodial orders, for purposes of completion of investigations. You know, cognizant of the limited jurisdiction of this court under Section 8, subsection 2 of the Magistrates Court Act 2015, our references to Article 29 is only in passing and for purposes of laying basis that every person, I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. In further laying of the basis that Article 24 of the Constitution allows for limitation of rights under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification. And where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important, as informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Ngugi J, as he then was, in Sudi Oscar Kipchumba,
they have the right of making submissions. We have made our submissions. So that once they have done this, they will surrender this for cross-examination, and they'll have no right. Procedurally, it is the deponent to be put on the dock, and the deponent is cross-examined. The respondent lawyers submit. It's the reverse. And that's why I'm asking, is my old JV abdicating the role?
My assignment was just laying the basis so that once the deponent comes to the door, then we can proceed from there. So let maybe just finish with your basis. I believe it's more or less an opening statement.
He has done an opening statement.
Yes,
We
let him
literally
finish.
then be doing an opening statement to lay the basis and counter what has been said, because he's doing actually an opening statement. We'll also be seeking that we also put an opening statement and before the court.
So
That's
Sorry, I do not understand the basis of that argument, because we are arguing our application with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts. So I'm almost done with the law. But sometimes he does that to take me off-road, and he knows I never get off-road. Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Jalango, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial orders. And it says, at paragraph 24, if you permit me to read, so even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged, and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that, Your Honor, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest. Now, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And Your Honor, the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by this quadruple interest and without refining or essentializing any. You know, I dare say kizungu kubwa. Having highlighted those two texts, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. You know, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interest, and as equally important, the interests of the public to ensure safety and security. You know, with that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am also obliged and this is a question from you. Thank you.
Your Honor Makori. Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Abdurrahman Jibri, dated the 16th of June 2025. It is an affidavit in support of the notice of motion, dated the 16th of June 2025. Your Honor, I'll only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation. And these are the preliminary investigations by IPOA, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious publications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6D On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10/7/6/2025. That is 10/7/6/2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6/2025 and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested. And this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations.
You are still a master. What will be the respondent disclosing this?
Your Honor,
The information the DPP is giving, it is not them who depend. It is the one who depend who should be giving us those paragraphs in paragraph 4. Then the DPP can buttress their submissions based on that. Right now, the DPP is turning himself into a witness. And we cannot cross-examine the DPP. It is fair and just. The witness who depend takes us through is a judge.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of. Because
It's a dicey situation because
yes,
you're literally taking us through the but I'm sure you have your own strategy
yes.
on how to keep the application.
The defense
Don't go into details
Yes.
of the affidavit. I'm sure the defendant will have a chance.
Yes.
So I need to proceed, but don't go too much into the
No,
position.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because we have already indicated that they want the deponent on the dock for cross-examination. Yes, Your Honor, what we are... Yes, the CCTV, yes, we said paragraph 10, the respondent is the custodian of the station records and the surveillance system, that is the CCTV. that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigation. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. And it is subject to investigation. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there's a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days. To continue holding the respondent. And in addition to the 21 days, Your Honor, we'll be seeking an order that we access the forms of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference which has already been done. With that, Your Honor, we will be inviting the deponent, the doc, for the cross-examination.
You can testify from here. You know, we'll be seeking that these are standing to an opening statement. You'll be allowed to put a 3 minutes opening statement.
So let me finish.
But
Let me finish. And then
I swear by the name of the Almighty God, the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God.
Yes, did you state to the court your full name?
Your Honor, I am Herman Jibril. Jibril for you, J-I-B-R-I-L. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes. Did upon this affidavit and before court?
Yes, Your Honor.
Yes, kindly proceed with your affidavit with the indication from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPO is currently conducting with regards to the brutal murder of Albert Ojwang. This is pursuant to Section 6, 7, and 25 of the IPO Act. Your Honor, on 8th day of June 2025, IPO learned the death of Albert Ojwang by the police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. You can only adopt the truth. Because unless there's any other crucial information.
That's all right, that's okay.
yeah, I will conclude, but just give a highlight. Not necessarily going to paragraph, just a highlight, and then we can adopt it. Just a brief highlight. You okay with whatever you've said so far?
Yes.
Whatever you've heard in the affidavit, yeah. So we can proceed with the prosecution?
Yes.
Is that okay?
Yeah, that's actually not that. They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness, Mr. Jibril.
So it's that question. How many people will cross-examine?
Free.
Three. You yourself are doing
Me, what? Kanzai.
So only three of you?
Yes, we'll cross-examine it. The others will submit. Thank you. Mr. Jibril,
Yes, Your Honor.
can you confirm your position at IPOA over this matter?
You're asking me, huh?
Obvious. Yeah, that's what I'm asking.
Your Honor, as indicated, I'm a Senior Assistant Director, investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or the position of the National Police Act?
IPO Act.
Under IPO Act. And under IPO Act, is it true that you have still arresting powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPO Act and Section 7 of the IPO Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPO Act and Section 7 of the IPO Regulations Act.
Gives you the powers as that of a police officer.
Yes,
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want us.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. And do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we'll have an objection.
I've not asked the question.
We can see. Your Honor,
I've not asked your question.
Your Honor, at least should I be allowed to make the objection?
Of what?
Let me just object, then you
No. You wait until I ask. I'm just told to look at it. It might be just to admire it.
Your Honor, we'll be requesting the court to just, yes.
Let me hear, let's hear his objection.
Okay.
That's right. Your Honor, the witness before the doc has come here on the basis of his affidavit on the factual matters. And that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed, this matter should have been the subject of an inquest and not a miscellaneous application. So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed. But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
Is the law a fact? Yes, it is. Is he in a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are fearing and telling us they're coming through the window? If we come through the window, please respond and throw us out of the house.
There is a submission. I've not asked any question. I've only told you to look at that section.
Confined.
You know, it's a matter of evidence on the facts. And it's an affidavit for everything. So let's leave it to the facts of it.
After I've asked the question,
Yes.
then that is when an inference can be done, whether it's a question of law or a question of fact. I've not asked what. I've only told him, look at section 386.
Your Honor, just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit. There is no reference to section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are issues of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
Yeah, I just only
Let's not complicate it. Let's leave it. It's an affidavit.
purely, I've not asked any question, Your Honor. If we only had what I'm asking, and I ask a question of law, then the court can stop. Let him have that. Let him look at what.
Once you're pointing to the law, then you
No.
And that exactly is our objection, that we can't refer to the law. That is, maybe, see, a counsel is not understanding our objection.
Very well.
Maybe counsel, maybe rather than asking him to look at the law, yeah, why don't you put the questions to him?
Correct.
Very well.
Put the question, rather than ask him.
Very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the IPO Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
Your Honor, we are still objecting. Council is still taking the same route.
He came under the act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court.
Don't give him answer. Don't give him answer.
And this is a witness.
This is our witness now.
He's not an advocate. Let him come in front. Let him not be given answer.
No, Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to refer to the law. Do not mind if you read the law to him and ask questions.
Read paragraph 3 of your down.
Listen for me to get an answer.
No, you read it. I didn't write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1 and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying. You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is yours in the affidavit talks the law. Give me the law that gives you mandate to investigate a person who died in a police cell. That is simple.
I have indicated the sections. 6.1, 7.
Tell the court. Just tell the court.
Yeah, hold on. I have indicated section 6A, 7.1 and 25.1 of the IPOA Act.
Could you kindly read to the court those sections that gives you that? The IPOA, just read to the court those sections for the benefit of the whole world. We don't work for IPOA.
Because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just give us the...
We from selective amnesia when he is cornered. It is there. On any form. Just read the form. Read the section. 6, you read.
Section 6, your Honor talks about functions of the authority.
Yes.
Here means IPOA. That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offences committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police, specifically. Now, question on specific.
Your Honor.
Your Honor, this is
Can we allow the witness to read?
This is a question.
Sorry, Your Honor.
Before he even says anything, this is a question that has been put to this witness. It is about what he has said in his affidavit. He is being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him. Let him answer.
Mr.
Yes. Yes, Your Honor, I just wanted to indicate. Section 6 has been referred to in the affidavit. The witness has been asked to read, he has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that Section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit, but we would be guided.
The better convention.
Yeah.
So let him answer. If it falls under the ambit of that section 6, let him just say.
That's right, that's right.
It falls under that provision of the law, and let's leave it at that.
That's right, yes, that's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out. That's all we ask. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
So the brief.
Yes.
If it's not there, it's not there.
The question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's good enough.
Yes, and custody.
Doesn't mean the court has gotten what we have asked. The question has been answered. We'll do submissions on it. That's all. Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOD and was later moved at the Jakarta police station by OB 50-13-6 at 18:05 hours.
The DCI officers arrested him at what time, according to your there?
I said around 3.
You read exactly what you said.
I've not indicated the time.
That's what I'm asking.
Yes.
It is not indicated when the DCI officers arrested him.
Yes.
Where did they arrest him?
At the DCI headquarters.
And the nota Eldoret confirmed that the accused was not arrested at Eldoret. The respondent.
According to the officers who handed over me to Mr. Taalam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that I released the false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my information.
I'm saying what is in social media is that the respondent
Your
was
Honor, I
arrested.
can only answer what is in this affidavit.
Sorry, Your Honor.
Let's not digress to those issues.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my evidence.
That's why I said, are you aware? You are not aware, you are not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, On that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, one Keton. For your order.
If you say so.
Thank you. Putting it to you. And the DCI authorized these officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, you have said time and again.
I'm putting it to you.
Please,
You don't need to answer.
Please answer me, ask me what is in my affidavit. Let's stop checking, counsel.
Counsel, I've only put it to you, I've not asked any question.
Is it in my affidavit?
I'm
The
putting
question
it
I'm
to
asking
you.
to you is it in my affidavit?
For the
Answer is
benefit
no.
of the court, I'm putting it to you, then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my
I've not asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keton. As I put it to you, for the record purposes.
Samson Taalam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, one Keton, Kiprono. Who is it?
Is that my affidavit?
I'm putting it to you, counsel. You are counsel. When it's a question, I'll ask you a question. I'm only putting it to you
Please
for knowledge purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
Cool that. It's a long thing. The state is rich, it can bring water for both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
The fact that he was brought under the escort of the DCI officers means he was arrested and brought to IPOA.
The court has taken that. Let's go further.
Sorry, Your Honor, I think this may be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matrix we have is the one given by the witness before court.
The only way to prove a falsehoods is by bringing facts that are truth. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
So, sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that he's telling us is, I put it to you, and we hope it does not go to evidence.
But counsel, just to allay your fears.
Yes.
The evidence that I'm documenting is from you.
That's right. Thank you very much.
Not from Mr. Johnson.
Thank you.
Because as we put it rightly, he's not giving evidence.
All right.
He knows the procedure.
Thank you.
That's why
He's a teacher of the law.
Yes, and that's why I told you, Riti now is mature to be a judge of the high. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
The respondent at the material time of the incident He was also commanding Central Police Station, exercising command of the Central Police Station, as persons of influence, and has capacity to interfere with the ongoing investigations and likely victims.
Do you have any evidence to show that he was in full command of the police station at that time?
As an OCS,
No. I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty in command?
you know what that would suspect is? That you are the presiding magistrate here. Do you have the power of this court? I mean, once you are an OCS, you have got the power over that station. Come on, counsel.
We have agreed that you don't have it. You are looking for it. Let me put it fine.
And
let me put it to you.
And Your Honor, just to answer also, whatever evidence that I have, I have put as an extra. Anything else which is not here, is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
And I've asked a simple question.
Yes.
Among the annexures, have you produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident, he was the officer commanding the station at Central Police Station, in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear, you have not attached. All that's what you are looking for. It's not attached there.
And maybe to answer your question, any other attachment you might ask, it's not there, save for the OB extracts.
Just don't go. And you are a lawyer. When I say I put it to you, don't respond. I have not asked any question.
And I put it.
I know. We have our own legal team. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the OCS, the police station, and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has heard this. Let's go. Paragraph 15. On the question of him liking to plan. You there?
Yes.
We have agreed there is no any material presented.
Yes, nothing.
Let's proceed. Paragraph 10.
We go back.
Oh, I asked you paragraph 15.
Yes.
I'm going to paragraph 16, sorry. Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you. Paragraph 18.
No material attached.
No material attack. Paragraph 17. I've gone back because there's a question I want to ask.
Yes, sir.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now? Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on up? Because I was there yesterday myself. It's not true that the scene of crime has been released to the police. still a scene of police station.
That question is not, it's not in there.
You've run very fast. Don't lie that is. So you cannot, there's no material to show that.
Nothing as such, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same?
What's the question? No material fact.
There is no material fact.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will reply you to the High Court decision. The judge who is dealing with that.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter. He's the one who argued that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 21. 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we have to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
About recording statement and interference are two things. Wakili, I've
I
asked one
responded
question.
to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Then being police officers, I'm saying yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because counsel, you know very well, the authorities, the Sagari, Duarte Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your value?
Nothing at all.
Thank you. Report that. Paragraph 24. What are you addressing?
That we are saying is released, the security is not guaranteed due to the public anger demonstrated by the case. Come again? I'm just saying it is
Yes?
I'm saying that the gruesome murder of the deceased has elicited widespread public anger. And therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit. For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be correct. It is an apprehension. And you are very aware that the is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not aware of it.
No. You will fail to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell and he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
what
in my
do
affidavit.
you specifically want him to do?
All I have stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a seizure.
Oh, wait,
Sorry, no. Yona, where is the provision that does not allow you? Surely.
Where is
You
the
are asking
provision?
for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision, and council can put it. He can continue putting it to him that this provision does not allow you, not the negative provision.
Maybe rephrase your question.
I'm rephrasing. You know, which has a problem is preparing for the judge. It's not a key to this matter. You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specific. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your varmints are not based on any scientific, because you never consulted a forensic expert? It is you swearing 21 days.
Yes.
And I've asked you, should the court, why 21 days? Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness.
No,
I have seen an annexure here.
Can I check, yes?
I've seen an annexure there. We were given an annexure that has. Is it yours?
Yes.
Or disown it?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting
It's a draft.
these orders?
Counsel, this
No.
is a draft.
No.
It's a draft.
Which is saying, is the office of the DPP or IPOA that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality that in this court already you have decided, not the court decides? Who decides? I hope it ceases from being
I hope
the norm.
we can save time by admitting that the application was drawn by the office of the DPP. What we have annexed as an order is a draft order. It is not the first time today, is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it, it's not binding on the court. So that we save time for counsel and his client. We
Which have only for good practice.
We admit.
Avoid doing the judicial work. Leave the courts to do their works.
So maybe Mr. Witty, let's not delve so much on that here.
Yes.
I think what Mr. Witty is saying is just a practice that they have adopted from the DPP's end, which is not a good practice.
It is not good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. But I was chased. Thank you very much. Let me allow Mr. Kangai to proceed. Oh, sorry, you already said it.
You said
If an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching. He's like on the forum.
So, Mr. Kangai is Mr. Shadrach.
They will release Shadrach.
We're just trying to put in order. It should be a difficult one. After Mr. Shadrach, Mr. Keton plays legal basis. Then I'll wrap up the application. I think if Umbeta and Ngunyi will be making a submission on that one.
Your Honor, with your permission, I will ask very few questions to my colleague, Mr. Jibril. Unlike my seniors, I am the soft one.
And I hope you are around so that you don't ask again the same questions which I have already answered.
Yes, I teach law, just relax.
Mr. Jibrin's sentiment is valid.
Yes.
I was about to make the same commentary.
The problem is his body. Cliff, make sure he eats well.
So that we just avoid repetition.
Thank you. Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edward Lagat.
Please repeat the question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Eliud Lagat.
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think we've agreed that what I'm going to answer is what is in my avowment.
Please just listen.
No.
This is cross-examination.
I decline to answer that question, Your Honor. It is in public domain who is the head of IPOA.
Just respond. That is your work here.
I'm responding.
Please respond. Who is the chairperson of IPOA? That is your work.
My response is it is not in my affidavit.
Yes, yes. JV just informing.
No, no, no.
I mean,
Your Honor, we have agreed that I will be cross-examined on what is in this government. The chairman of Independent Police Oversight Authority's name or his position is not in my affidavit.
But you come from that background.
Yes. Yes. And the council knows who is the chair of the IPOA.
I don't please answer the question. Who is the head of the body where you hail from?
We don't have a head. IPOA does not have a
So
head.
who is the chair of the IPOA?
Yes, that should be a right question. The chair of IPOA
Answer yes.
is one Ahmed Hassan Isaac.
Thank you. Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor,
No,
I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose is my senior. My senior should just
No, I'm not your
be
senior.
kind enough to
I'm not your
respond.
senior.
Yes, he looks are deceitful, but
Your Honor. Yes. Yes. Your Honor.
you cannot argue the court.
No. Order. Chair. Let me say this. Let me say this for the record. No, let me say it for the record. And Your Honor, protect me. The counsel who is on the floor asking questions should only answer. Learned senior should stop pointing at me. You will have your time to ask me questions if you require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair
Not within your knowledge.
is it's not within my knowledge, and please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge, and believe.
What is the basis? What happens to your ruling?
And after all, Your Honor, the application we are making is about the extension of continued detention of the suspect. It's not about what happened on the backyard. What you are pointing is bad faith.
That's why it was trying to lay a basis.
You just give us a minute.
Take a break.
No, we don't need a break. I think just
No, we don't need a break. We don't need a break.
just 1 minute.
That is what we are doing.
It's our intention of making if they ask who the chairperson is, just answer if they see them crossing the line and the first so don't let us use that. Yes, that's what they're doing.
We are not like this is just calm down.
So calm down, just answer what Yona, thank you. I know.
Let's just ask anytime they corrupt.
Yes.
They cannot fight it. Also, what matters to the system.
Thank you. Mr. Jibril,
Yes.
Counsel, please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025 where the chairperson of IPOA, was in the company of Mr. DIG Eliud Lagat and the Inspector General of Police and others?
I'm not aware.
You are not aware. Thank you. So you have not, Your Honor, you have no information that indeed your chairperson held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press conferences.
Leave those several.
So I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that he has presented before court?
That is not in my affidavit.
No, you have in your affidavit.
No, I'm saying
yes.
The answers that you're looking for is not in my affidavit.
No, I am asking a very straightforward question, likely to attract a yes or no.
Yes.
I am asking you again. In lieu of your paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court
No.
any material?
No.
You don't have any material?
No.
Thank you. Your Honor, that should be all for me. Thank you.
The two. I'm actually going to take very limited time in the form of 2 minutes. 2 minutes and stop it.
Then I can do 125 minutes, depending on how it's Now, Mr. Jibril, I want you to remember the testimony that you've given us just a few minutes ago, where you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my affidavit. That's my answer. Yes.
You made a representation to this court and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
Now, Your Honor, the scene of crime here I'm talking about.
Correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book?
The occurrence book is a digital. It's not.
It's a digital.
It's a digital book. Yeah.
Is it with your possession right now?
No, it cannot be.
It cannot be.
It cannot be in my possession.
Have you extracted the relevant entries on that particular day?
Yes, and attached to the affidavit.
Thank you. Now, number 2, about the CCTV, can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV itself is not with the police station. It is with the forensic team.
No, what was extracted is only the DVR. But the entire, you can't carry a whole screen.
It's okay. That's what I want you to tell me.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all you want.
Good morning. Good afternoon.
Good afternoon. I can you allow me to ask you just 2 questions. I want to take you to paragraph 6A. where you have said the DPO received a complaint from the Deputy Inspector General of Police. Confirm?
Yes, Your Honor.
Was it an oral complaint or a written complaint?
It was a letter, a formal,
It's a letter.
yes, a letter to the
Have you
DC.
provided that letter this court?
No, it's not attached here.
It's not attached here.
Yes.
Thank you. Kindly go back again to paragraph 7, where you say the respondent was arrested and under the Langata police station, OB number 50.
Yes, yes, Your Honor.
Who booked the respondent at Langata police station?
The booking was done by myself.
It was done by yourself.
Yes.
Thank you. Are you aware of the law governing the booking of a person at the police station?
As per the IPO Act, yes.
As per the Act?
Yes. And the regulations.
Are you a police officer or a former police officer?
I'm not a police officer. I'm an
Have
IPO
you been a
employee.
police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 21. Now, paragraph 21, usually you're saying there are co-conspirators. Confirm?
21, yes.
Do you know the co-conspirators by name?
That is part of investigations. I cannot reveal here.
No, I'm just saying, do you know by name, not their names? Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
Counsel, this is what I've been saying. Let me answer her. The thing is,
Let me help you with it.
yes.
Just say yes or no. Do you know the co-conspirators?
The matter is under investigations.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 25. You have said that there was the murder of the deceased was planned, executed, and their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that with certainty?
Yes.
Have you provided evidence to that effect? Or
No.
the attempt to cover up?
It's under investigation, but not attached to this affidavit.
You have said yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover
As of
up?
now, no.
No.
Yes.
Thank you so much. Thank you, Anna. That is
I think, Your Honor, that will be the end of the examination of the witness. He will lay down, once he's discharged, his acquittal will lay the basis for our next line of approach.
Even we would like a few minutes of re-exam, because that follows cross-examination. So, Mr. Jibril,
Yes, Your Honor.
my work is to calm you down completely. And make you
No, actually, I'm calm and composed.
I'm glad. Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing.
Okay.
What is the basis of your request for detention continuing, in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now, on a scale of 0 to 100%? Doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in command of the station. do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Jackson.
It's just one question, the examination. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in your affidavit, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor. The reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And this is actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. I believe that is all from my end.
Thank you, Your Honor.
I'm glad that you confirmed that you were calm.
Yes.
Thank you.
Then allow the next phase of our team, led by Peter. Now we proceed on check out as we are ready, we are only asking for the benefit of
How many will be submitting?
4. There's Kiton, there's Langat, there's Kisika.
We are fine. The only thing that we'll be asking is there something that has been filed so that you can be served? Or it's an oral? Yes, very well.
We'll serve you with authorities, simply. Our team serve the state with the whole.
So just like brevity, this issue is valid in itself. So just brevity, just direct to the point here.
Your Honor, for the record, I remain Felix Keaton, and also there's also another additional attorney at law, Vincent Yegon, also is part of the defense team.
Present, Your Honor.
Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for pre-plea, pre-trial, or pre-charge detention has been settled in law, is well settled in law. And as such, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person has a right to be released on bond or bail unless there are compelling reasons. Your Honor, In order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is section 36A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this section 36A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus Republic, the 2016 decision, whereby, Your Honor, in this section, it lays the two-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the IPOA. And the other also burden also, Your Honor, rests with the Honorable Court. And as such, Your Honor, under section 36A, it is very clear that pursuant to Article 49(1)(f) and (g) of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we admit that. Then the second thing, Your Honor, is that they must apply in writing. And they have done that through this motion application. But now, Your Honor, the greatest issue that they must also do, Your Honor, is that under section 36A clause 3D, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigations have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, they have already gone through the cross-examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I will refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of the affidavit. They are building a case that you should continue detaining the respondent because he is likely to interfere with the investigation. We submit, Your Honor, that that is not a cogent reason. And we'll invite you, Your Honor, to consider the authority which we are provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Gigonyo has indicated succinctly, and I will humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has settled the law that for such a threshold to succeed, the investigations must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Chirchir and Godfrey Kirui, whereby the same threshold.
Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing, so that we are able to respond there.
Your Honor, we have already filed our list and digest of authorities dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. The decisions and everything, we have already furnished. It's the last decision.
The last one.
Counsel, the one which is on the, there is the one.
Sorry. I am looking at your document, sir. I am alert.
Thank you.
The document written respondents list and digest of authorities.
Yes, Your Honor.
I am looking for Mercy Jebet. Do you have it in the list?
There is another one which is, look.
So it's not in the list?
No, it is in the, is the one you are holding.
Thank you.
There
No,
is
this
also
is
another.
the list. It does not have Mercy Jebet. Does it have it?
You already have an authority, the one in next to your phone.
You know what we are informing the court is that we didn't have it in the list. So if he has added it, that's okay. That's
Yes.
what we're asking.
They have
So we can
already
have
put
the
the
paragraph.
authority, Your Honor. You have already defined it. Yes.
And I think I'm comfortable.
Yes.
I have the message there.
Yes. And they equally have.
Yes.
Yes. Yes. So Your Honor, if I may, it appears there was an oversight, Your Honor, but I know the court takes judicial notice of all the citation, of all the authorities which we have already provided the citation, Your Honor. Sorry, Your Honor, he has interfered with the flow of my thoughts.
My apologies. My apologies. I am not in that business like my colleagues.
Yes.
The two that musketeers.
So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also illuminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the Honorable Court. And the also decision which you have also cited, Your Honor, the William Chishir case, whereby Justice also Mutuku has said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11, and 20 of the affidavit. Another link, Your Honor, of the affidavit is that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and outrage leading to demonstrations which at times have been destructive. Hence, the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold waters is that we will humbly beg to refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Chebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again slide into grief. How and why in this age and time should people take the law into their hands to harm the accused? The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the said community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. And the community in question should let the law punish the accused. This should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the courts will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limine. The court the High Court has settled the law on that. On the other hand, it is even the duty of the police to also guarantee the safety of the respondent. And you have also been told other issues, Your Honor, that they need time to do forensic, to subject the grudges to forensic, etc., etc., etc. We submit, Your Honor, that all those reasons that have been given, it can be done without the need for any custodial order. So we submit, Your Honor, that from all the reasons that have been adduced, none is cogent and none should pass the master of the law, because they have already done what they ought to have done, and any proposed investigations can be done without the need of subjecting the respondent to custody, Your Honor. Having submitted the limb, Your Honor, that they have failed to demonstrate the reasons necessitating further or continued detention of the respondent, Your Honor, we submit on the second limb, whereby their statute also, Your Honor, has also given the court the latitude or guidance on what should do. And we shall invite you, Your Honor, to consider Section 36, Clause 5 of the Criminal Procedure Code, whereby it is stated that a court shall not make an order for the remand in custody of a suspect under subsection 5 unless there are compelling reasons for believing that the suspect shall not appear for trial, may interfere with witnesses or the conduct of investigations, or commit an offense while on release. So, Your Honor, even having submitted that they have not adduced that reason, that is a duty that the court also must also satisfy itself before granting any custodial order, that there are compelling reasons that the suspect will not appear during the trial. And there is no such reason that has been advanced by the state, Your Honor. And the other aspect of interference, Your Honor, we have already submitted that there are no material information to persuade you that there is a need to further detain the respondent, Your Honor. And in doing so, Your Honor, on the duty imposed on the court in the two-tier threshold, that is the threshold in the second tier threshold, which is the duty of the court, will invite you, Your Honor, to adopt the reasoning of Justice B.J. Otieno. There is a High Court decision in Ramadan M. Hassan versus DPP. It's a 2017 decision, whereby at paragraph 15 of that decision, Your Honor, it is at pages, we are finding that authority. It's at pages 43 to 46 of our bundle, whereby the judge reasons this way, Your Honor, that I must add that a judicial officer before whom an application is presented seeking to limit the enjoyment of a suspect's fundamental freedom akin to the right to liberty is duty bound and enjoined by law and the Constitution to be extra vigilant and not to interrogate whether the facts presented to it melt the dictate and spirit of the law invoked before it and are in consonance with the attributes and general philosophy of the Constitution, which guards against arbitrary and unjustifiable limitation or enjoyment of rights and fundamental freedoms. So Your Honor, will humbly persuade you to adopt that reasoning to be extra vigilant in granting such an application, Your Honor, because this being a temple of justice, Your Honor, you hold that mighty sword of Damosil, and you should always strike for the rule of law and nothing else. So having demonstrated, Your Honor, the two-tier threshold, that it fails in every limb, we conversely, inversely submit, Your Honor, that on the other hand, there are compelling reasons to release the respondent on bond and or bail. And we'll humbly invite you, Your Honor, to consider certain factors. Number one, Your Honor, is that the respondent before you cooperated with investigation. I accompanied him, Your Honor, on the 11th of June, 2025, when he was summoned by the Independent Policing Oversight Authority to record a statement under inquiry. And he did so, Your Honor, and he was released. Thereafter, Your Honor, he also presented himself to the DCI Gigiri headquarters on 13th of June 2025, whereby, Your Honor, he sought assistance to be escorted to the IPO offices to seek whether he is required there or not. And indeed, in my company, he was escorted, Your Honor, and he presented himself, and he cooperated, and he agreed even, and he was duly booked at Langata Police Station, Your Honor. So he has already cooperated, Your Honor. That is a factor which you should consider in granting him, Your Honor. The other factor which we invite you to consider, Your Honor, is that there is already issued in place an interdiction letter, which is duly signed by the National Police Service. And Your Honor, in order to put into perspective, an interdiction letter, Your Honor, is a sua generis document which sets certain conditions, which is a replica of the conditions imposed under Section 36A of the CPC, and also, Your Honor, which technically it holds in abeyance the powers of a police officer. In other words, Your Honor, it removes the teeth from him. He can't do anything. And from that interdiction letter, Your Honor, which I had a privilege of seeing as an attorney at law, Your Honor, he has been told categorically that he should report to the OCS, to the Eldoret police station. So there is also a condition, Your Honor, to demonstrate that is not a flight risk. There are already safety mechanisms which have been imposed by that interdiction letter, Your Honor. We'll also invite you, Your Honor, to consider the primary consideration of bond and bail. That is to secure the release of an arrested person as and when required. And irrespective of the issues, Your Honor, whether there will be any intended charges or anything, he is still an arrested person within the meaning of Article 49 of the Constitution. And as such, the rights under Article 49 has been activated. And such rights, Your Honor, should be enjoyed to the greatest extent possible. And in interpreting, Your Honor, and in contextualizing the situation, Your Honor, we will humbly persuade you to adopt a latitude that is beneficial to the suspect rather than the state. And in doing so, Your Honor, we will humbly invite you to adopt the philosophy of in Justice Kimaru, as he then was, in Michael Rotich versus Republic, whereby, Your Honor, it's an authority from pages 22 to 26. Whereby the judge here, at least in this decision, Your Honor, conceptualized and also reiterated the importance of liberty being in pressures that are personal liberty. Right to liberty should be respected at all times unless there are legal reasons for such person to be deprived of his liberty. And the police should only arrest a person when they have a prima facie evidence that an offense has been disclosed which can result in such a person being charged with a disclosed offense. Your Honor, the reason why we are citing this decision for avoidance of doubt is to reiterate the importance of liberty. It's not about the holding charge. So even in their response, Your Honor, they should not deal with the holding charge. Reasons being, Your Honor, I had a privilege of interacting with this decision, Your Honor, when my then client, Major Rotich, may his soul rest in peace, was arrested, and we went all the way to High Court. And the court made certain findings, Your Honor, including one holding charge and this liberty. But the holding charge question, Your Honor, has already been, there is a mutation of law. So that is no longer applicable, Your Honor, and we shall demonstrate the reason why that decision is no longer, the question of holding charge is not applicable, is because of the second decision, which you have also furnished you, that is in Kenneth Omondi, Ocheng, and 38 others, whereby the same judge also reiterated and illuminated the law, knowing that there was a development, because between that Michael Rotich and this Kenneth Omondi decision, Your Honor, there was an amendment to Section 36A of the CPC, so which drastically changed the law. That's why we will also adopt the reasoning of the judge that the reason why this court in the Michael Rotich case required a charge or a holding charge or provisional charge to be presented to the court when the prosecution is seeking extension of time was first to inform the arrested person of the likely likely charge that he or she may face, and secondly, to inform the court on the serious nature or otherwise of the charge. So that was the reason in that development of the jurisprudence, Your Honor. So in grounding our application, Your Honor, and also we'll also invite you to consider another factor, Your Honor, that the suspect before you, the respondent before you, is still presumed innocent. That is verse 1 to Article 49, I think 1A, 52A of the Constitution, whereby he is presumed innocent unless otherwise proven. So no matter the veracity, the public pressure or anything, Your Honor, he is still presumed innocent. So we'll also invite you to consider that one, Your Honor. And finally, also we'll also invite you, Your Honor, to consider that is not a flight risk. Yes, fixed aboard, both within Nairobi and also in Eldoret. And it has not even been demonstrated also that is a flight risk. So those are the issues, Your Honor, that we'll humbly invite you to consider in granting him bond or bail, Your Honor. And we'll humbly beg to ground our application on that under paragraph 3 to 5 of the bail and bond policy guidelines, which will guide you, especially on the situational analysis. And we'll also beg to ground our application also, Your Honor, and to support the same also, as per the decisions which we have cited, which we have already provided. That is the authorities, especially the Court of Appeal in Jayendra Gimji Malde versus Republic, whereby the Court of Appeal settled the issue and reiterated the constitutional provision that an arrested person has the right to be released on bond or bail unless there are reasonable reasons not to be released. And also the Court of Appeal has also reiterated that now, unlike in the past, even those persons charged with serious offences such as murder are entitled to bail on reasonable conditions. And the applicant here is certainly entitled to that bond, Your Honor. And also on that other issues also, Your Honor, which we have been told that they are compelling reasons, except the question of interferences, safety and interest, Your Honor. We'll also humbly invite you, Your Honor, to adopt the reasoning of Justice Mativo in Republic versus Danfo Kabage, and I know my learned senior Cleveland Beta also argued that matter, whereby the High Court has laid the test of compelling reasons. That compelling reasons or grounds ought to be proven to the satisfaction of the court, and mere allegations or possibility is not enough, and bail cannot be refused simply because the accused has been charged with a very serious offense, and that the burden of proving such to the court that there is one or more grounds rests solely with the prosecution, and there is no time whereby the burden can shift to the respondent, Your Honor. We'll also rely on the other decision which we have tendered, Your Honor, the Betty Mutahi Kimeiwa case, which was also a reaction to the Michael Rotich case before the amendment, and we have already furnished to you, Your Honor. And as such, Your Honor, we'll invite you to decline the application before you because the same is bereft of meat and substance to stand on, and to invite you to unleash your sword of Damocles and to strike for the rule of law and to admit the respondent to bond or bail. And we'll humbly, Your Honor, suggest that he be released on cash bail or 7,000 shillings. That is what he can afford, because we also know the conditions of the officers in the Republic of Kenya. And also, Your Honor, in also making your ruling, Your Honor, we'll humbly invite also you, Your Honor, to make certain policy, or in your obiter dictum, to find or to make certain policy considerations. Because the reason why we are here, Your Honor, is also because of the legal edifice of IPOA, which is created under the Independent Policing Oversight Authority Act, number 11 of 2011. Whereby, Your Honor, I wish, as the people of the Republic of Kenya, we had constitutionalized or made IPOA one of the commissions or independent officers under Article 248 of the Constitution. It would have been good. But what the Parliament did in that Act, Your Honor...
Sorry, Your Honor. Sorry. You know, Mr. Hiton is a good friend. He has like a law teacher, like my friend Shadrach Wangui. What he's inviting the court to do, which is now justifying, is beyond the jurisdiction of this court. You cannot make policy. So he should just save us time so that we go to what this court can do. Although he had a very good point, but this court has nothing to do with it.
It was just an obiter dictum observations, Your Honor. And the reason why they do that one, they know is that in what the IPOA Act, what the parliamentarians did was to establish a weird...
Your Honor, we have objected to that time.
It's okay, Your Honor.
This court has no jurisdiction.
I withdraw, Your Honor, and we humbly beg to submit, and I beg to rest my submissions and raise their questions for me.
Okay, thank you.
Thank you.
I've really appreciated your industry.
Thank you, Your Honor.
You brought it so eloquently.
Thank you, Your Honor.
And erudite.
Thank you, Your Honor.
So I believe the others will not have anything to say.
It is Langat. Good afternoon, Your Honor. I'll only go straight to what my colleagues on the other side submitted earlier in the opening statement, and more specifically on the case of Sudi Oscar Kipchumba versus the Republic. The decision which I believe they will share with you, I've just looked at it and analyzed while sitting here. These are decisions that, in essence, will allow you to dismiss the application today. I'm happy because they are the ones who brought this decision. It's a very beautifully done judgment, ruling. The test that they have been argued by my colleague under Article 49 are found in this ruling. I want to address one or two issues. The first one is the aspect of the investigations. They have made a picture, or they have painted a picture that our client is likely to interfere with investigations. Your Honor, today, the witness, in his affidavit and while being questioned in examination in chief and in re-exam, has told this court that they are in control of certain important exhibits which are not within reach of our clients. There's no way you can interfere with those items, exhibits, which are in control of IPOA. Your Honor, the second aspect, which I believe will be addressed by my learned seniors, is the aspect which came out in the affidavit, the issue of forensic analysis. The forensic analysis of the phone, the gadgets, will be done and shall be done in the absence of our clients. IPOA has officers capable of doing that job conclusively without any input from our clients. The attempt by the applicants to say that our client should be in custody while this process is going on should not be entertained by this court. This court, Your Honor, should abide by the binding decision in Professor Ngugi's decision and release our clients on reasonable bail, which my colleagues have suggested, and put even other conditions which our client is willing and ready to abide by. Those conditions, the discretion is with the court. We therefore submit that the application has fallen short of meeting the threshold set by various decisions cited by my colleague and have been supplied to the court, meeting the requirements of compelling reasons. Finally, Your Honor, the affidavit that was filed before this court does not produce, does not even have did not even attempt to convince you for those compelling reasons. With that, Your Honor, I beg to rest my case. I'll allow my seniors to have their time. Thank you.
Your Honor, with the greatest of brevity, can I? Your Honor, whereas my good colleagues have also examined the veracity of the affidavit at the point, my good colleague, what to call him Dr. Kiton, has laid the legal basis, the premise upon which creates a question in the application before you. I'm just reminded before my good colleague, Mr. Ombeta, submit in his finality to say that the application notice of motion that is before you seeks in prayer A, B, C, D. One, that the matter be had inter partes, which is what is happening right now. It is seeking in prayer B, that the respondent be remanded for 21 days pending completion of investigations. It prays in prayer C that the electronic gadget seized from the respondent be subjected to forensic examination. And finally, any further orders that the Honorable Court may deem fit. I am certain, and it's a position we take, that we have no objection to prayer C. If the so would want to examine the gadget, given the fact that they are already seized and in custody of the gadget, as to whether we oppose or not, we would not control what they intend to do. Principally, what Your Honor is being called upon is to give a continuation of detention of 21 days to complete investigations. We submit, Your Honor, that in the deposition of my good friend, Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigations. I doubt that he would need 21 days to complete the remainder of the 51% of the investigations. Why am I saying this? The persuasion of my good colleagues that, Your Honor, be minded of the provisions of Section 123 of the Criminal Procedure Code, read with Article 49(1)H, as well as G of the Constitution of Kenya in matters bail, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with white powers to make such a determined decision on bail bond, would grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as is being prayed, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We are saying that the custodial detention should not act as a punishment. Given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence, as said, is placed before you that the respondent is likely to interfere with any witnesses or investigations as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety. And we would only ask, is the police saying that they are unable to secure and safeguard the safety and interest of its citizens? In the threshold of that, Your Honor, we plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators or by way of affidavit that he is likely to become uncooperative moving on forward in this particular investigation. And should in both leans as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, Your Honor, and that if they are limited, it would not in any way prejudice the investigations, as nothing would bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. As we oppose that application, we plead with Your Honor that you admit the respondent to bail bond pending this investigation, and in the event of such disinclinement, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent in custody. Benigni, we submit, Your Honor.
Okay, Your Honor, I was thinking that my colleague Shadrach was going to say something. But let me start with the whatever he wants to add, he can add. But the last one is yes. Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean to the respondent in this matter. Please grant him. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus OM case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Tushapatia mengi mkonazi mpaka tumechoka, sio? What does the court say something to do with compelling reason? And this is the Court of Appeal decision in the realm of the Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to his phones. What they did not tell you is that he gave them the passwords and they're keeping quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the window. Let's finish that one. It's a simple thing, a 1 minute thing, doesn't need 21 days. They tell you that there are CCTVs
that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit, and what he has said here on oath, is that, in fact, I've given you the password. Pick a password.
It's not about the password.
Just confirm.
It's not about the password.
They're telling you.
Yes, Your Honor. The issue is not about the SIM or the password. It requires a lot of things.
No. Your participation. Watching me. I'm running the show now.
Okay.
Now, they are telling you about witnesses. They are not telling you in the affidavit which witnesses, but they are telling you something else that is imaginary, that they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the DD police station, headquarters CID, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the detention. Then have they convinced you, Your Honor? And I am saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say pre-bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why you have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court,
including the prosecution and including the officers, the police officers. That includes also IPO. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I am certain that they ignored it because Mr. Whitty, my friend here, would have told them. And I don't know why he's not telling them, but Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant this fundamental right. Article 20, sub-article. Might start by wanting to grant to ensure that this person enjoys the fundamental right. But they still give you this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear articles. So that the court, once it has noted this kind of, can I call it, bad faith application, will be able to see. Let me qualify it to say, why does it come under bad faith? You have an IO who has come to court today. What does the IO do? He refuses to answer questions. Just he will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves. Why should you believe him today? That once you release this person to him, he shall be treated well. Why? You cannot believe him because he denies publicly even his own boss. I know now how Jesus felt when Peter just and then, Your Honor, if that is a position, and then they come and tell you, oh, this there is public order and issues like that, and that the safety of this person depends on them keeping him in custody. Where does that come from? Because Article 29 is clear. This gentleman must enjoy his fundamental rights. The security, it is provided by the state. It is guaranteed. Guaranteed. So they can't come here by a mere application and tell you that he cannot be safe. And they don't quote that article in their application. Why? They avoid it intentionally because it is black and white and it is clear. So, bad faith again from the investigating officer. And he is my friend. Now, Your Honor, I know when the state wants to respond, they will start telling you about probabilities. They want to tell you that nowadays it's on probabilities whether a person will appear or not, that they anticipate. And you can see from their affidavit, they are alleging, they are saying likely to abscond, likely to interfere. It remains likely. Let us change that scenario of likely. Let us move from the bail bond issues first of all. Let us go to what the law says today. Law is very clear. And there are three authorities that I will give the court. One I've already given, the one of Oyamo. Then there is one of Richard David Alden versus the Republic, that is the number 40-something. Oh, you see, I'm even so confusing myself. Richard Alden versus the Republic, that is the High Court case number 48 of 2016. And then the other one is White Sagarai versus the Republic. That is number 61 of 2012 before the High Court. Proudly, let me say that I appeared in the matters. What did the court say when somebody makes an allegation to do with somebody is going to interfere? The court did not say probably. The court said must put evidence, must show something, must produce something. Why? Because if we were to leave it to imagination, the sky would be the limit. So if you are saying somebody is interfering with witnesses, you must show that he directly interfered or indirectly, or has attempted. In the affidavit that you have been given, nothing is there. They are saying likely. That was held by Justice Korir in the Dwight Sagarai case and was also supported by Justice Lesit as she then was in the Richard David Alden case. If you're going to say somebody is going to abscond, what does the judge say in Lesit? She says that you must be able to show that an attempt has been made by the person to try and abscond. Not only that, maybe there's a ticket, plans of traveling, or arrangements made. So I'll ask you, Your Honor, and I will give you the answer. Have they given you that? Then the answer is no. Such that even in the case of Oyamo, when they are saying that public order and public interest and all that, the court in Oyamo versus the Republic, and this is a court of appeal case, and that is the law. What does it say? For you to say that there is public order and rest and all those things that they are saying, they must show. All this unrest that has been going on has not been because of the OCS. Tuesday, tomorrow, there will be an mandamano in reference to somebody else. Not him.
You know, we hope that goes on record. That matter of fact, we hope goes on record.
Your Honor, it's even on social media, and let me tell you why they can't tell me not to say anything about social media. In his affidavit, he said they got these issues from social media.
You know, don't shut me up. If that counsel can go to social media, we just asking the court that as he says it from social media, please record it for us. We will use it.
Yes, Your Honor. And if that is the position that they are going to say and they are going to use it, let me tell you, Your Honor, it was not in relation to the OCS. It must be mentioned that it is the OCS and it must be accurate. Let us not generalize. That is why that law has never been overturned. Until today, it has never been overturned. So, what then does that leave the prosecution with? An empty shell, Your Honor. Today, they have come to this court, not, as I said, to do this case in a proper manner, but in bad faith, which have demonstrated, and an affidavit that does not meet the requirements of Article 49, and at least what they will come out from with here is that at least I've given them a definition of compelling reasons. Mumeelewa hiyo? Yes. Thank you.
Let me read. Cliff can mislead the court. Your Honor, for the public and the country to get that paragraph, that is the citation Cliff has said, criminal case number 61 of 2012, Republic versus Dwight Sagarai, in page 4, paragraph 3. Your Honor, the court is saying, for the prosecution, that is Owiti and my good friend Makori, to succeed in persuading you on this criteria, however, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect, incriminating communication between the accused and witnesses, close familial relationships between the accused and witnesses. That is not clear from better say, but it was part of that decision. That is the decision that we are seeking. When I was cross-examining my good brother, he admitted he has nothing, no material.
would want to examine the gadgets, given the fact that they are already seized in custody of the gadgets, as to whether we oppose or not the control of the gadgets. Principally, what the is being called upon is to give a continuation of detention of 21 days for investigation. We submit, Your Honor, that the position of my good friend, Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigations. I doubt that you will need 21 days to complete the remainder of the 51% of the investigations. Why am I saying this? The persuasion of my good colleagues that, Your Honor, be minded of the provisions of Section 123 of the Criminal Procedure Code, read with Article 49(1)H, as well as G of the Constitution of Kenya in matters bail, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with wide powers, to make such a determined decision on bail bond with grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as is being traded, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We say that the custodial detention should not act as a punishment. Given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence as said is placed before you that the respondent is likely to interfere with any witness or investigation as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety. And we would only ask saying that they are able to secure and safeguard the safety and interest of its citizens. In the threshold of that, Your Honor, we would plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators by way of affidavit that he is likely to become uncooperative moving on forward in this particular investigation. And should in both things as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, and that if they are limited, it would not in any way prejudice investigations, as nothing will bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. as we oppose that application, we plead with Your Honor that you permit the respondent to pay bond pending this investigation. And in the event of such disenchantment, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent. Benign, Mr.
Okay, Your Honor, was thinking that the colleague Shadrach was very specific. But let me start with whatever you want to add, you can add. But Your Honor? Yes. Okay. No, Your Honor. Let me start first of all by asking that let me request that the court first of all, Your Honor, grants bail to the accused. I mean to the respondent. Please grant bail. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? Because now I believe that once they have come under Article 49G and Article 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they fail at least miserably. Am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyamo case, the court has indicated what is supposed to be a compelling reason. Paragraph number 23. What does the court say something to do with compelling reason? And this is the Court of Appeal decision in the realm of Justice Republic. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once you have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want access to his phones. What they did not tell you is that he gave them the password and they're keeping track of it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the way. Let's finish that one. It's a simple thing, a 1 minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important. So what they have there is a shell. And that's the reason why they can't pick it. That's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then by telling you they are going to interfere with the investigations. But in his affidavit and what he has said here on oath is that, in fact, I've given the password.
It is there. Just they are telling you.
So you don't have to break it, yeah?
But the issue is not about the scheme or the password.
You can't just say
It requires a lot of things.
no, your participation. No, they are telling you about witnesses. They are not telling you the affidavit which witnesses, but they are telling you something else that is imaginary, that they are yet to get some other witnesses who they are going to take it. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement and inquired. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the Gigiri police station, headquarters CAD, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the litigation. Then have they convinced you, Your Honor? And I'm saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say free bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote Article, all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why you have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPOP. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I'm certain that they ignored it because Mr. Whitty, my friend here, would have told them. And I don't know why he's not telling them. Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant this fundamental right. Article 20, sub-article B. might start by wanting to grant to ensure that this person enjoys their fundamental rights. But they still give you this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear article. So that the court, once it has noted this kind of, can I call it, bad faith application, will be able to see. Let me qualify it to say, why does it come under bad faith? You have an IO who has come to court today. What does the IO do? Refuses to answer questions. Yes, he will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves. Why should you believe him today? That once you release this person to him, he shall be treated well. Why? You cannot believe him because he denies publicly even his own boss. I know now how Jesus felt when Peter just said, Lord, and then, Your Honor, if that is the position, and then they come and tell you, oh, this, the republic order and issues like that, and that the safety of this person depends on them keeping him in custody. Where does that come from? Because Article 29 is clear. This gentleman must enjoy his fundamental rights. The security, it is provided by the state. It is guaranteed. Guaranteed. So they can't come here by a mere application and tell you that he cannot be safe. And they don't quote that article in the application. Why? They avoid it intentionally because it is black and white and it is clear. So bad faith again from the investigating officer. And here's my friend. No, Your Honor. I know when the state wants to respond, they will start telling you about probabilities. They want to tell you that nowadays it's on probabilities whether a person will appear or not. That they anticipate. And you can see from their affidavit, they are alleging, they are saying likely to abscond, likely to interfere. It remains likely. Let us change that scenario of likely. Let us move from the bail bond issues first of all. Let us go to what the law says today. Law is very clear. And there are three authorities that I will give the court. One I've already given, the one of Oyamo. Then there is one of Richard David Alden. Public, that is number 40 something. Oh, you see, I'm even so. Richard versus the Republic, that is the High Court case number 48 of 2016. Simonai. Yes. And then the other one is Dwayne Sagarai versus the Republic. That is number 61 of 2012 before the High Court. Proudly, let me say that I appeared in the matters. What did the court say when somebody makes an allegation to do with somebody is going to interfere? The court did not say probably. The court said must put evidence, must show something, must produce something. Why? Because if we were to leave it to imagination, the sky would be the limit. So if you are saying somebody is interfering with witnesses, you must show that he directly interfered or indirectly or has attempted. In the affidavit that you have been given, nothing is there. They are saying likely. That was held by Justice Korir in the Dwight Sagarai case and was also supported by Justice Lesit as she then was in the Richard David Alden case. If you're going to say somebody is going to abscond, what does that say? She says that you must be able to show that an attempt has been made by the person to try and abscond. Not only that, maybe there's a ticket, plans of traveling, or arrangements made. So I'll ask you, Your Honor, and I will give you the answer. Have they given you that? Then the answer is no. Such that even in the case of Oyambo, when they are saying that public order and public interest and all that, the court in Oyambo was the Republic, and this is a court of appeal case, and that is the law. What does it say? For you to say that there is public order and rest and all those things that they are saying, they must show. All this unrest that has been going on has not been because of the OCS. Tuesday, tomorrow, there will be an mandamano in reference to some.
You know, we hope that goes on record. That matter of fact, we hope goes on record. We are
it's even on social media, and let me tell you why they can't tell me not to say anything about social media. In his affidavit, he said they got these issues from social media.
You know, we are telling you that council can go to social media. We just in the court that as he says it from social.
Let me. Cliff can mislead the court. Your Honor, the public and the country to get that paragraph, that is the citation Cliff has said, criminal case number 61 of 2012, Republic versus Drat Sagar, in page 4, paragraph 3. Your Honor, the court is saying, for the prosecution, that is Owiti and my good friend Makori, to succeed in persuading you on this criteria, however, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect, incriminating communication between the accused and witnesses, close familial relationships between the accused and witnesses. That is not clear from letter, but it was part of that decision. That is the decision that we are seeking. When I was cross-examining my good brother, he admitted he has no material before this court. Your Honor, in that case, to read the final authority there, I agree with the holding in Panju versus the Republic, 1973, East Africa Law Reports 284, where the court in dismissing the prosecution's fear of interference with witnesses
Mr. Witty, let's not delve so much on that here.
Yes.
I think what Mr. Witty is saying is just practice that they have adopted from the DPP's end, which is not a good practice.
It is not good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. But I was chased. Thank you very much. Let me allow Mr. Kangai to proceed. Oh, sorry, Your Honor, I said if an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come and he was teaching. He is left on the forum.
So, Mr. Kangai is Mr. Shadrach.
They will we're just trying to, in order, it should be a difficult one. After Mr. Shadrach, Mr. Keto will play his legal cases. Then I'll figure out the application. I think if Umbeta and Mr. Ngunyi will be making a submission on that.
Your Honor, with your permission, I will ask a very few questions to my...
I therefore find that the Director of Public Prosecution is under statutory duty under Section 388 of the Criminal Procedure Code to institute an inquest proceedings before a competent court in terms of Section 387 thereof. I also consider that the court should give effect to the deceased's family interest, knowing how the deceased met this death for emotional relief and establish whether there was any criminal or tortious causes which may attract consequences in penal and pecuniary redress. Your Honor, nobody should stop the court to look at the law as it is, whether that law has been argued on this floor, or so long as that law we are mentioning is in statute. Whether lawyers don't argue it, whether lawyers don't present it in form of appeal, the court is duty-bound to look at the law. Does it have jurisdiction to sit in this matter, or it needs to be declared an inquest court so that we move to the scene of the crime and that work starts? Your Honor, that is for the abundance of caution that the court have given you the authority. You will assess whether this matter, and now Mr. Whitty can understand what I'm saying, flagrant disregard to sections of the law that are statutory is political. That is why McClant is here. We have no more to add.
Yes, Your Honor. We will have very brief comments. Unfortunately, for us, or luckily, we do not have the leg room to go political. Your Honor, I'll start with the last point on whether or not an inquest which has been brought through the window is available or is an obligation of this court as suggested. It's something I've written on, so I can quote one decision on this. Understandably, the decision that Mr. Omari has referred to the court to, if I got him right, is a decision of number 96 of 2011, Your Honor? 93 of 2011. So, is my good friend, he may not have seen what Honorable Justice William Musyoka says in Dennis Rosanna Manibe.
Could you give us the
I will give the citation. We didn't know you raised the...
We don't do this. It's okay. Just give the citation.
Your Honor, Dennis Rosanna Manibe and 4 others versus ODPP and 2 others. The good judge is not only an authority in law of succession, he delivers a beauty of a judgment. The citation of this case is Kakamega Criminal Revision number E001 of 2022. E001 of 2022. And basically what the judge is doing is the nature of inquests in post-2010 Kenya. And I'll read one paragraph. This is what he says. I quote him, the first is whether it was necessary, which is what Mr. Omari is telling you, in the first place to conduct the inquiry in view of the letter by the first respondent, the ODP, The purpose of conduct of inquest proceedings is to primarily determine the cause of death, particularly where it is suspected that the same was by hand. Where the persons responsible for the death are known, there will be no need to conduct an inquiry. The suspects ought to be arrested and arraigned to answer to a charge of either murder or manslaughter or any other related offense. The inquest will be conducted where there is doubt or where the accusation is clouded in some mystery for the court to unravel the mystery. Where there is no mystery or the circumstances are fairly clear, then the first and second respondents need not ask the court to conduct an inquest. Now, this is part of the law on inquest post 2010. There is a similar decision by J.B. Ojwang. He was a judge by the time. He rose all the way to the Supreme Court. And the decision which I would invite the court to have a look at is Nisha Sapra versus Republic. This is way before the Constitution of Kenya 2010, but it still has the same principle. There's also the decision of Honorable D.S. Majanja J. May the Lord God put his soul in eternal peace, in re-estate of Philip Otieno Odhiambo. Re-estate of Philip Otieno Odhiambo. This is reported in 2015. And finally, on the question of inquest, one of my favorite judges, Justice Mwongo, my phone has just gone off, Your Honor, but I'll provide Justice Mwongo's decision.
Help us more knowledge. You know we are students. In those decisions, where was the scene of the death? Just tell the learned.
All right.
Only that.
Sorry, Your Honor, we will not answer that now. Yes. Thank you very much, Your Honor. I am done with the point. Thank you. Thank you. Thank you, Your Honor. I am well guided. Actually, that's why I started with it first. We are done with the question of the inquest. Now, Your Honor, I wanted to read for you the decision of Titus, the Court of Appeal decision on Titus. I think the defense have treated this matter with some lack of seriousness, with a lot of respect. And that's why you hear questions like, release him on a bond of 7,000, release him on free bond. Your Honor, this court is bound by Section 60 of the Evidence Act, and this is 60 subsection 1 subsection O, to take judicial notice of matters of public notoriety. Judicial notice of matters of public notoriety. This court is human and does not live in vacuum. This court has eyes. You can see the number of media officers here. You can see the number of Kenyans in court today. This matter cannot be treated with a lack of seriousness. And what is the matter? The matter is that we are saying a Kenyan died in a Kenyan police station. That Kenyan is identified as Albert Ojwang. Now, of course, we are both laws, but that's not why I'm making this argument. True. And that is a disclosure of conflict, possible conflict if there was. There is also admission from the defense that the person sitting as the respondent before you is the OCS. While they had questioned it in the affidavit, they have admitted severally. And not just the OCS. He's the OCS of, according to Mr. Kumekucha, one of the greatest stations in Kenya. And that is not enough. According to Mr. Omari, he has been in the police service for 29 years. Now, with that point of reflection, just before I get to the decision of Titus Ngamao Musila Katitu, a police officer who has been in service for 29 years, who else would have more influence, either on witnesses and or the investigations? And with that point of reflection, allow me to just read paragraph 1, because the Court of Appeal, this is what the Court of Appeal says in the decision of Titus Ngamao Musila Katitu versus Republic. This decision is delivered on 24th April 2020 by Justice William Ouko, may rest in peace, Fatuma Sichale, and William Ouko, I withdraw that, Fatuma Sichale and Ole Kantai. And this is what they say. This is why it is hurting me at this point. The blue code of silence which we have been told not to talk about, is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and in Africa. Kenya is part of Africa. Allow me to just read this. It is the unwritten rule according to which police officers never provide incriminating information about their colleagues, to close ranks in silence, and to cover up knowledge of a fellow officer's wrongdoing with a collective blanket of self-preservation. The offense we are talking about today is the offense of murder. There is no greater offense leading to self-preservation than the offense of murder. We admit that all offenses in Kenya are available, but there is no greater need for self-preservation where a police officer, no less than the officer commanding the station, is intended to be likely charged with the offense of murder. A feeling of esprit de corps among officers who by and large depend on each other for their very risky lives as they confront the violent and hostile one of policing and crime. This background is important, and I hope it is also important to us today in our consideration of this appeal, because the police in Kenya, as we shall demonstrate, the three judges are speaking, as we shall demonstrate in this case, as in others before it, has in certain circumstances engaged in the practice of covering up for each other. And the court proceeds to give examples. So that we are saying, when we say that the respondent before you is likely in the act of self-preservation interfere with ongoing investigations, we are not plucking it from the air. There is basis of it. The Court of Appeal has seen it before. Now let us go back to the... Yes, I hope the court will have an opportunity to look at the other parts. Let me go back to the application so that we get back the court to our application, because we may have lost what we are asking. And Mr. Kangai did a good job in referring you to the orders we are seeking. Your Honor, the limited order in prayer number B is that the respondent be remanded at the Langata police station or any other police station within the Republic of Kenya as the investigations may dictate, to enable the applicant conclude investigations. The main primary reason why we are asking to hold him is to enable the applicant, IPOA, complete investigations. So now, there are very few questions which are necessary to contextualize. Is Albert Ojwang dead? Yes. Did he die in a police station? Yes. Was the police station, Central Police Station in Nairobi? Yes. Is the respondent the officer in charge of that station at the material time? Yes. Has the IO informed you that investigations are ongoing? Yes. His affidavit evidence has not been contradicted or controverted. There is no denial that there are investigations. Coupled with the public interest, even as we presume the respondent innocent, would it be in the interest of the victim? We have seen, just like them from social media, the father of Albert Ojwang, confused, running across Nairobi. Is it in his interest as the victim and his family that the respondent should be released on 7,000 or freeborn? Because the rights belong to who? Accused person. And our answer is no. Your Honor, we are at an investigation stage. A decision may, most unlikely, but may still be made that the respondent in the dock is not to be charged. The decision to charge him or not has not been made. We are asking you, because of the complexity of the matter and because of the blue code of the police, which has been judicially noticed by the Court of Appeal of this country, allow us 21 days to complete investigations. If the investigations are complete before the 21 days, Mr. Jibril is a good man, except that he gets a little angered like me sometimes. If we complete these investigations before the 21 days, Mr. Jibril, you can confirm we can come back to court.
Yes, Your Honor, I do confirm.
We pray with you that approximation as per now is that 21 days will do justice not just to us, but also the respondent, so that we establish, as his advocates are suggesting, that he was not involved in this matter. As I conclude, Your Honor, there is a deliberate distinction by prioritization of Article 49(1)G and Article 49(1)H. I have always believed that when provisions of the law are put distinctly and separately, they mean different things. So that on the burden and standard of proof, Article 49(1)G, which requires at first appearance that he be charged or informed of the reason for his detention or to be released. Once we have given the reason, we have met the threshold. And that the arguments have been made, and that explains why most of the decisions that have been presented to you are decisions on bail pending trial. So that all we needed, in my view, in my very respectful view, is that the threshold is met once the reason is given and it is satisfactory to the court. The arguments about compelling reasons, arguable reasons, are reasons which are better still placed on arguments of bond pending trial. Let me give the last point, which is apprehension vis-a-vis likelihood. I have had Mr. Mpeta, who I respect so much because the decision in Dwight Sagarai is one of my best read decisions in this country, tell this court to ignore the bail and bond policy guidelines. Although he said it in passing, but that was very unfortunate in my view. Because the bail and bond policy guidelines is intended to standardize the application of the law on bail and bond in Kenya. And if I get it right, I think it is clause 4.9 of the bail and bond policy guidelines. The word likelihood is used at least 3 times. So that the likelihood to interfere with investigations is a sufficient ground, even if you are pending trial, to deny bail. But on this lower threshold of abundance of probability, where we are asking you to let us complete investigations, the likelihood to interfere with investigations, as my brother will tell you, where there has been uncontroverted evidence of interference with CCTV, that likelihood is very high. And because of the blue code, please hold the respondent for at least 21 days. I submit and I am ready. Thank you very much.
Yes, Your Honor, just to finish, I would want to refer you to the affidavit. And this is the reason why I was highlighting earlier about some paragraphs. Let's look at paragraph 11 of the affidavit, where the respondent is alleged to have hired a technician to interfere with CCTV system at Central Police Station. This is in a bid to tamper and interfere with the investigation. This is a compelling reason. Your Honor, paragraph 13D, the same affidavit, that after the fatal assault of the deceased, the respondent, together with other persons at Central Police Station, are suspected to have instructed and caused to have made false entries in the police. Paragraph 13B. Yes. That the respondent, together with other persons at Central Police Station, are suspected to have caused to be made false entries in the police records, of course with a view of misleading the investigations. Again, paragraph 17. That the CCTV surveillance system installed at the respondent's office, the respondent's office, had been interfered with the DVR power cable disconnected and the DVR logs indicated that the operating disks had been changed and formatted. And we have gone further to even indicate the timings. That is on the 8th June 2025 at 7:28, 43 hours and 7:32, 29 hours. Your Honor, paragraph 18, still on the tampering of the CCTV. Paragraph 20 and 23 on the issue of interference with the police officers. These are compelling reasons. With that said, Your Honor, we still request and we urge you that you grant us the 21 days, which will be sufficient to complete the investigation. That is all.
Your Honor, if it may please you, I'm sorry for coming in late. My name is Julius Juma. Yes, I request that I be placed on record for the family of the deceased. And if you allow me, Your Honor, Sorry. Yes, I was traveling from Mutembei. I've just arrived. Yes. Thank you. Thank you.
But I think now you don't have a chance to respond, but I can assure you that the team by the state council, by manyora, so we can
Your Honor, I wish to confirm that I have followed the proceedings even while I was traveling.
Oh, okay.
Yes, and I associate myself entirely with the submissions made by the state because I do not want to reopen proceedings again. But once I do that, then my colleagues would want to respond, and it will be a back and forth. And therefore, I associate myself with the submissions made by the state, and I will urge the court to do justice to the deceased and to the deceased family. Thank you.
So first of all, I wish to thank all the parties for the arguments and submissions. The master has really been our assistance to the court. I believe this issue of the jurisprudence on without detention is just a matter of, case to case, adopting whatever the law says or what the facts are. So I want to thank you for that. I propose to come up on Wednesday at 2 p.m. for a ruling. So in the meantime, I'm not sure. Can the respondent still be between the remanded at the remand?
Yes, Your Honor.
We have not.
Most of the time.
No, sir.